Hi, and welcome back to Chapter 7 in your Commercial Transactions curriculum. Today we're going to talk about legality in contracts. It's another of the elements that has to be present in order for us to have a legally binding and enforceable agreement. Remember, so far we've talked about offer and acceptance, consideration, mutual assent between the parties, the capacity or the ability to contract, and now we're talking about a legal purpose for our contract. After finishing this chapter, I'd like you to be able to list the different types of illegal contracts, describe contracts that violate public policy, define a covenant not to compete, and when it's appropriate to use such a covenant, determine when exculpatory clauses are unconscionable, and understand the doctrine of divisibility. Even after competent parties have accepted an offer, provided consideration, and understood the terms for the necessary mutual assent, one or two more elements must be present for a contract to be enforceable. The one we're going to talk about today is legality, and in some cases, as we'll see in the next chapter, there has to be a writing for the chapter. But the contract must have a legal purpose and legal subject matter to be enforceable between the parties. If the contract is illegal, it's void on its face. Sometimes we run into the issue where contracts that are legal when made are later deemed illegal. In a case where the legislature makes the subject matter of a contract illegal between the time of the making and the time of performance. We're also going to take a look at contracts that are illegal based on statute or public policy. These are very common occurrences, and they create a void contract. So remember, what we're trying to create here is a legally enforceable agreement. Therefore, it should come as no surprise that contracts that have something as their subject matter that is illegal are not enforceable. Take, for instance, a contract where you hire somebody to rob a bank. Well, robbing a bank is illegal, so you can't go into court and ask the judge to enforce a contract to rob a bank. It's not legally enforceable. The subject matter itself is illegal. Illegal agreements go beyond just a person's criminal activities. They also are found in contractual terminology that violates laws on things like usury, wagering, and unlicensed persons. In each case, the subject matter of these contracts violates a specific state statutory provision. Usury laws regulate the amount of interest that individuals and businesses can charge in a loan or credit transaction, and they usually set a maximum rate of interest. A usurious contract exists when money is loaned at a rate higher than the maximum rate of interest in a state. To protect the public from greedy excesses of business or individuals, state put a ceiling on the amount of interest that can be charged by a lending institution. There's a good example from Texas in your book under Exhibit 7-1. And because of the public policy interest in protecting citizens from predatory lending activities, these areas are heavily regulated, and you'll see them in retail installment contracts, and credit cards, and things like that. Another area that generates illegal subject matter for contracts is wagering laws. Most states prohibit gambling, betting, or participating in games of chance. And if they do allow it, it's very heavily regulated. There's a few states that do. When they do, it's very heavily regulated, and the government is involved. For instance, Nevada with Las Vegas and New Jersey with Atlantic City allow casino gambling. Individual state lotteries are also an example of a legal wagering situation, and states allow it because it produces revenue that is used to avoid higher taxes for things like schools. Another interesting area is Sunday laws, or blue laws, as they're called in some states. There are still some areas where either the state or the locality prohibit the formation or the performance of contracts on Sunday. You'll see this where stores are actually closed on Sunday. Sometimes it has to do with the subject matter, alcohol, gambling, bars, things like that. And sometimes it's just a blanket prohibition on contracting or business on Sundays. And the logic behind Sunday laws is that persons should have a day of rest set aside. In many states, they've been repealed or eased to allow the sale of merchandise and generate more revenue. Also, unlicensed performance laws affect contracts. There are certain professions which have a licensing requirement. Things like the practice of law, the practice of medicine, being an accountant, being in architecture. And public policy demands that there be some type of training and licensing requirement so that we just don't have anybody practicing medicine out there or practicing law. If someone without the proper license tries to practice in that professional area, any contracts they made and any contracts they make are void and unenforceable. Another area that generates a lot of controversy are contracts that deal with personal matters, things like surrogacy, palimony, patrimony, and things like that. Now, these contracts are not legal in all states, and before you enter into, or one of your clients enters into a contract of this type, you want to make sure that you check your state's laws and understand that it's going to be a very heavily regulated contract area. So a surrogacy contract is one where a woman agrees to have a baby for another woman or for a couple in exchange for a fee. The fee is usually substantial and includes medical expenses. Upon the birth of the child, the surrogate gives the child to the biological parent and terminates all parental rights. Public policy, as you can see, makes this a very difficult area of the law. And what we worry about, or what the public worries about, is economic coercion, taking a look at the best interest of the child, and also whether or not the sale of a human is really something that we want to make the legal subject matter of a contract. Frozen embryo and sperm donor agreements are another difficult area. If everything goes well and the husband and wife or the couple or the partnership stay together, usually don't have any problems. But what happens upon divorce? If the couple divorces, who owns the rights to the frozen embryos at that point? Can the woman go through with the artificial insemination of the embryo after divorce, or can the former husband say, no, I don't want that to happen anymore because I'm involved in this? Who bears the duty to support the child in that case? When we look at the contractual nature of the marriage relationship, we're really moving in that direction, that more and more of the marriage relationship is coming under the auspices of contract law. Prenuptial and palimony agreements are no exception, in two areas where we have a lot of focus. We'll talk a lot more about this in your family law class, but a prenuptial agreement is an agreement about what happens if couples divorce, and palimony sets out the financial duties of unmarried cohabitants, and it can be express or implied. In most cases, prenuptial agreements are going to be enforceable as long as they're fair and reasonable. Another area that has raised a lot of public debate is the contracts surrounding human organs and bone marrow. We know that donation is legal, but what about the sale? What about selling a kidney or your liver for a fee? Is that something that public policy would dictate we should do to encourage donorship, or do we want to stay away from the sale of human organs? In this case, it's pretty clear that public policy comes down on the side of staying away from the sale because of the potential dangers that surround infusing money into a situation like this. So donation is still legal. In almost every case, sale is illegal and potentially criminal. Take a look at the chart on Exhibit 7-3 in your book. I think it lays out pretty clearly the things we've just talked about. Let's move on to covenants not to compete. In many circumstances, parties are going to agree not to engage in competition for a period of time and within a specific geographical area. These are known as covenants not to compete. Such provisions are frequently included in contracts for the sale of business or employment contracts. Because we live in a free market economy where competition is encouraged, restricting competition raises questions of unfairness, and so we look at these contracts very carefully. In some situations where you may see these non-competition agreements, let's talk about the sale of a business. If I have a successful ongoing business and I want to sell that, the buyer doesn't want me to sell it, turn around and open up that same business right next door to them and take all of their business away from the one that they've just purchased. So we may include in that agreement a covenant not to compete for a reasonable amount of time and covering a reasonable geographic area. Such a covenant would be enforceable as long as it doesn't go beyond the bounds of reasonableness. Reasonable in terms of the geographical area, the time period, and the restraint on competition. If it's overly broad, if it says I can never participate in this type of business again anywhere in the United States or anywhere in the world, obviously that's not enforceable. If it says the business is in Jacksonville, we don't want you to compete against us in Onslow County for the next year, that's probably going to be reasonable, but it's going to be on a fact-specific case-by-case basis. Okay, the last type of contract I want to talk to you about is not really a contract, but more of a clause that's part of a contract in most cases. And we call these exculpatory clauses, and what they do is they limit one's liability. We've all seen these. For example, if you're in a parking lot and the parking lot says you're parking at your own risk and management will not be held responsible. If you go onto a boat or you go skiing or something, there's usually a clause that says management won't be responsible if you get hurt. Things like that is going to be based on, again, the reasonableness of the exculpatory clause. Are the bargaining powers of the parties equal, or is one side unreasonably powerful? Did the other side have any bargaining power at all? So you're going to have a comparative analysis there. And you're also going to evaluate it from a public policy standpoint as to how offensive and oppressive the contract is. Let's look at the example on your book that involves a horseback riding incident. Basically, you have here a customer who went to some riding stables in order to take a ride on a horse. There were signs posted everywhere that said you're riding at your own risk. On the sign-in sheet, there was an exculpatory clause that said they had read the posted rules, they would abide by the rules, and they would release the riding stables from any liability. Of course, during the ride, the customer was thrown from the horse and was injured. Subsequently sued the riding stables, and the court said, look, the bargaining power was pretty equal here. The customer had the ability to just walk away and not take the ride. The warning signs were posted. He knew that this was an inherently dangerous activity. He signed a release agreement, so everything was fair and reasonable in that case. And so the exculpatory clause in that case was valid and enforceable. So what do we do if we end up with a contract that has illegal subject matter? There are generally three tools that the court will use when they have a case involving an illegal contract. The first two, in pari delicto and in locus potentia, not used that often, and basically involve a weighing of the less or more guilty party or some restitution for one side or the other. More often than not, we're going to see the doctrine of divisibility come into play. And that's where the entire contract is not illegal, but one portion of it, one clause of it, one provision is either illegal or unenforceable for some reason. This is fairly common. And the doctrine of divisibility says that unless the contract itself says the contract is not divisible, that the court can actually remove the offending clause, the offending provision, and enforce the remainder of the contract. So the courts are trying to make, if the parties wanted to have an agreement, the courts are trying to enforce the agreement, and in order to reach that goal, they're just going to remove one piece of it and let the remainder stay in place. So to summarize everything we've talked about today, one of the final elements in determining whether we have a legally enforceable contract is the legality of the contract itself. It can be illegal if it violates statute or public policy. Illegal contracts are void and unenforceable. An illegal agreement is one that's prohibited by law. A number of activities which violate statute will render a contract illegal. We talked about them: usury, wagering, Sunday business or blue laws, unlicensed practitioners. Those are the types of things that can render a contract illegal. Contracts that violate public policy can also be illegal. We talked about surrogacy contracts. We talked about frozen embryo contracts and exculpatory clauses. We also talked about what the court can do to try to save a contract or to provide some remedies in the case of an illegal contract. The most common one being the doctrine of divisibility, where they pull that offending clause out and force the rest of the contract. So that's all we have for this week. As always, if you have any questions, don't hesitate to contact me, and have a great week.